Okay, good afternoon, everyone, and thank you for joining us for another of our episodes of COVID Conversations, members helping members, and things are finally starting to look a little bit better on the horizon for all of us in isolation. For those that I don't know or don't know me, I'm Scott McCammon, President and CEO of Milton Chamber of Commerce, and there has been a lot of confusion about what's happening now that we're into phase one of recovery and looking towards further recovery. And we're very fortunate today to have Kelly Gray joining us to talk a little bit about the legal side of reopening as well. I know in talking to a lot of business people, there's a great excitement about being able to reopen, but there's also a great amount of nervousness in terms of, how do we do it properly? How do we make sure that our employees are safe? How do we make sure that, that we're doing everything properly from a legal perspective? So we reached out to Kelly and our friends at O'Connor MacLeod, Hanna, and luckily Kelly agreed to join us today. So thank you, Kelly, for that. And Kelly, I know you're going to walk us through your presentation, and for those that are joining us online, we do have the Q&A box open. Kelly's presentation is broken down into segments, so we're going to try and answer your questions at the end of each segment, and then if we've missed any, we'll circle back at the end and answer whatever is left over. So with that, Kelly, thank you again for joining us, and please, with your presentation.
Hi, everybody. My name is Kelly Gray from O'Connor MacLeod, Hanna. First of all, I'd like to say thank you, Scott, and thank you to the Milton Chamber for inviting me to do this presentation because, obviously employment law is something I'm passionate about, and I just wanted to put out a public service announcement to a lot of, businesses who really are struggling to try and figure out what to do to reopen safely and economically. So today, I'm going to be talking about how exactly to do that. So the topics that I will be covering today include changes to the employment contract, because the job that an employee might be coming back to isn't necessarily the same as what it was when they left it. How and when to reopen safely, how to deal with work refusals when your employees are invited back into the workplace, but they are not comfortable coming in or they can't come in. And what do you do? How do you deal with that? What do you do when you have employees showing symptoms of COVID-19, and how do you properly manage that situation without getting in trouble from a human rights perspective? What do you do when employees are calling in sick, but you don't really think they're sick? Performance managing telecommuters and terminations during a pandemic. So let's get started. So one of the big questions I have been getting from employers and from employees over the past 2 months is, hey, there's been changes to my employment contract. Is this a constructive dismissal? So, the big changes that we've been seeing so far are, temporary layoffs, reduction of pay or hours, or, people being given a different job because the job that they had prior to this pandemic just doesn't exist anymore. And, you may have heard there are many plaintiff side lawyers really advertising their services across various media, and what they're doing is saying that temporary layoffs or some of these reductions of work or changes to job duties constitutes a constructive dismissal, which would give an employee a right to severance pay or reasonable notice of termination. However, that's not necessarily the case, and the analysis is not really black and white. There is a bit of debate in the employment law community about this question, and because this is a pandemic and this is an unprecedented circumstance, we don't know for sure what a court will really do. But I think, and many other lawyers think, that there are several defenses that would be available to an employer in these circumstances. And I should pause here to say that everything I'm about to tell you is legal information. It is not legal advice. If you would like some legal advice about your specific circumstances, which all involve specific fact scenarios, please reach out to me or another employment lawyer and get some legal advice about your specific circumstances. So under common law, there is, sorry, this is distracting me. I'm just going to turn off my video here. So under common law, there is a two-step test to determine if an employee has been constructively dismissed. So first, the employer must have made a unilateral, substantial, and detrimental change to the terms and conditions of employment. Second, the second step, which often is forgotten, is that would a reasonable person in the employee's shoes conclude that the employer no longer intends to be bound by the employment contract? Then, even if the answer to both of those questions is yes, and there is a constructive dismissal, the employee has an obligation to what's called mitigate their damages. In other words, the employee has to take reasonable steps to reduce their losses and can't just sit on their laurels and expect to be paid. So with that being said, I just want to touch on how this analysis applies in the pandemic to the three situations I touched on earlier, being temporary layoffs, pay or hour reductions, and employees being given different job duties, and also to provide you with some practical tips about how to mitigate against the risk of a constructive dismissal. So first, with temporary layoffs. Under the Employment Standards Act, employers can temporarily lay off their staff without notice for a period of up to 13 weeks in a 20-week period. During that layoff period, the employer is not obligated to pay their employees or provide them with benefits. However, in certain circumstances, if the employer does one of a number of things, such as continuing benefits during the entire layoff period, this temporary layoff can be extended to a maximum of 35 weeks in a 52-week period. If the employee is not recalled within the requisite period of time, they are deemed to have been terminated and are entitled to a package. And the contents of that package really depends on, their statutory rights, their employment contract, and common law. So under normal circumstances, and I want to stress that, under normal circumstances, a temporary layoff, even if done in compliance with the Employment Standards Act, is often considered to be a constructive dismissal. And I think that's what a lot of those, plaintiff side lawyers have been saying. However, we are in a pandemic. This is not normal circumstances in my view. So the way that a judge will apply the law in this situation is not clear. We don't know for sure. And again, there is debate within the employment law community. Many employment lawyers, myself included, believe that employers have a number of defenses to these claims of constructive dismissal. So first, a court might imply a right to temporarily lay off your staff in the event of a pandemic or a mandated government shutdown. Second, the doctrine of frustration of contract, which is where an external event happened that was outside of the control and reasonable contemplation of the parties, has rendered the performance of the contract impossible, perhaps permanently, if not temporarily. And then finally, many employees understand the circumstances of their employers that have been caused by the pandemic and would not necessarily believe that the employer no longer intends to be bound by the contract, especially if the layoff is temporary and less than the 13 weeks. So ultimately, this is going to be a very, very fact-specific analysis to the question of constructive dismissal. I think there's going to be, or I think there is, sorry, a wide range of situations that businesses are faced with, and how a court determines your ability to temporarily lay off your staff will, I think, depend on where you are within that range. So for example, employers who have been forced to shut down by the government, and their employees are not able to work from home are on one end of the range, and employers who have a mere slowdown in revenue, but are still able to have employees work from home, but they're just not as busy, they may be on the other end of that range. So it remains to be seen exactly how a court will deal with that question, but that's my take on it. So the second situation is a pay or an hour reduction. So again, under normal circumstances, this would most likely result in a successful claim of constructive dismissal. But again, we are not under normal circumstances. So I think if the reduction is relatively small, so like 20%, and is expected to be temporary, it may not result in a successful claim of constructive dismissal. But if you're looking at a bigger reduction in work and or pay, you might want to take a look at the work sharing program that is being offered through Service Canada. And so essentially this work sharing program lets employers and employees jointly agree to a reduction of hours and to share the amount of work that's available amongst a group of employees. So the employers will pay them for the amount of hours that they worked, and then the federal government will pay them a percentage of their EI benefit, which percentage is determined by how much reduction they've actually had. So I think also there's so many government programs available to employers, and if you make the most of those programs, then a claim for constructive dismissal, I think, will be less likely to be successful. But again, to the topic of mitigation, even if, let's say, a reduction of pay of 30% is a constructive dismissal, the employee has an obligation to mitigate their damages. So this can, and often does, include accepting employment from their employer, unless it's humiliating or belittling, and if the relationship has become acrimonious. So, if an employee is faced with a situation where their employer is cutting their pay by 30 or 40%, and a job market where nobody's hiring, what would a reasonable person do? Would a reasonable person just take the bird that they have in hand, or would they just say, no, I've been fired, and go into a job market where nobody's hiring? I think a reasonable person would just accept it, and if they want to fight you about back pay later on, then maybe they can do that. But I think many employees would not think it's worth it, especially if they want to continue a relationship with the employer. But who knows? And if the job is different than what it was before, and especially if the pay is the same or substantially similar, that same analysis applies. So they still have the duty to mitigate. So if they're being offered a job that is different than what they were doing before, maybe they don't like it as much, would a reasonable person just take that job, or say they've been quit and go into a job market where no one's hiring? Again, I think a reasonable person would just take the job. And then if they do take that job, particularly if the pay is the same or just slightly less, they wouldn't really have any damages. So again, the claim would not be worth pursuing. So with all that being said, just to give you some practical tips, when you are putting an employee on a temporary layoff, or giving them a pay or hour reduction, or giving them different job duties, get the employee to sign that they agree to the change. So while it might not be a rock solid defense against such a claim, it would at least help to argue that it was not a quote unquote unilateral change. The second thing is in the case of a pay reduction or a job change, if the employee claims constructive dismissal, what you should do is immediately reoffer them the job in writing. Okay, so this would make it a new job offer that they can accept to mitigate their damages or not. If you don't do that, then you may lose the opportunity to say that they failed to mitigate their damages. So that's definitely something that you should do. In the case of a temporary layoff, if the employee claims constructive dismissal, you could consider recalling them immediately, or when you would realistically be able to recall employees. If they fail to return when you've recalled them, that in many cases results in failure to mitigate their damages. And then it would be capped at the duration of the layoff. So the next thing is, and again, this goes back to the government programs. So even if your employees are on a temporary layoff, and if you qualify for it, I suggest that you apply for the wage subsidy and then recall your employees to quote unquote work. Okay, so this is actually transforming the layoff to a leave of absence. Although you're encouraged, if you can, to top up the wage subsidy to 100% of your pay, you don't actually have to. But use of this program, if you qualify it, I think would lower the chances of a successful constructive dismissal claim. Because employees, they know that this wage subsidy program is there, and certainly if you qualify for it, I think they would expect that you would do so, that you would use it. And finally, you should update your contracts and your policy to give you the discretion to make these types of changes in the future. If you get your employees to sign a new contract now, it would most likely not be enforceable unless you give them something in return, like a signing bonus. But I also think that introducing a new contract, especially if it has some onerous terms in there, like termination clauses, or clauses that say we can temporarily lay you off without notice, that might just upset people, and it actually may add on to everything else and increase the risk of a successful constructive dismissal claims. And also, I can tell you from experience that it can also cause quite a bit of morale issues and cause some distrust from employees to the employers if you do it that way. So an approach that I've seen work better than just like rolling out all these mandatory contracts for people to sign is just to get a new and updated employment contract and use that for your new hires, or if you're offering promotions or some salary increase that's more than what an employee would be entitled to in the normal course, and then use that to make that new contract enforceable. So I think that's what I have to say about changes to the employment contract. I'm just going to open it up for questions now.
Okay, and again, we've got the question and answer box at the bottom if anyone does have any questions. Kelly, I think you've handled that quite nicely. We don't have any questions, so I think we can move on to the next section. All right, great.
So the next section is reopening, and I just want to preface this with I'm a lawyer, like I'm an employment lawyer. I am not a public health official. So I'm not going to be advising you about public health and health measures that you should be taking. But, I do have a few things to say. So first of all, our premier has said this, but I'm also going to say this to you. Even if you are legally able to reopen, you should reopen only when you are ready to do so. And I cannot stress this enough. Before reopening, you should be doing an analysis to determine if you can do so safely. You have a duty to protect the health and safety of your employees. So one question that I often get is, am I liable if an employee or even a customer catches COVID in the workplace and dies? And this is a scary question, but it's a good question. And I don't want to scare you, but I'm putting this in here because I want you to understand that there are implications if you are reckless about safety. Okay, so technically, yeah. So if an employee catches COVID and dies, or catches COVID and becomes very, very ill, you would be obligated to notify the Ministry of Labor, in addition to notifying the public health authorities. So the ministry will send an inspector out to inspect your workplace, and they will determine if you were operating safely or not. If not, you could be fined or subjected to some other penalties. And actually, in Quebec, and this was not this year, this had nothing to do with COVID, I think it was last year or the year before, but an employer who was, and I want to stress this, very, very egregious about safety. Like it was just ridiculous. The workplace was so unsafe and he was forcing people to work, but he was actually charged criminally with manslaughter. So, and there's also the Occupiers Liability Act, where if someone gets injured on the premise that you occupy and you didn't take reasonable steps to avoid such an outcome, you could be liable for the damages. So with that being said, and now that I've probably scared you all a little bit, the defense to all of these situations is doing everything that you can reasonably do to protect the health and safety of your employees, and for that matter, your customers. You have to be reasonable. That doesn't mean you have to be perfect. But to be reasonable, this means that you should follow the Ministry of Labor guidelines that relate to your industry. Follow the public health guidelines. You should, if you need to, if you don't have the expertise to be able to do this, you can call in a consultant to help you figure out, design plans within your office, or whatever it is that you need to do to ensure the public, the physical distancing and all that, and the sanitary requirements. Make a plan, implement that plan, and importantly, train your managers, supervisors, and all your employees on your new policies and procedures. You can't just put policies and procedures in place and expect people are going to know what they are. You need to train them on them, and you should document that training. So if you do it on Zoom, keep a screenshot or other electronic records to show who is there. And then you need to also make sure that your policies are enforced, and ensure that it is being enforced and consistently being enforced. Okay? So now you have a plan in place, and you've kind of implemented it and set everything up. Now you can reopen. But once you reopen, you should continuously monitor the situation. And by the situation, I mean both, the health situation that's going on in Ontario and in your community. But I also mean, this is a rapidly evolving situation. We're all kind of learning as we go, and there could be some workplace hazards that you didn't really realize were there. So you should adapt your plan and your procedures and your policies as you go, and continue to train your employees. Many return to work plans will be different across the variety of industries and across the different types of workplaces. Many will involve staggered shifts, so you don't have as many people working at the same time. If physical distancing is not possible and all other guidelines have been followed, you could require employees to wear some PPE, but this should be, like a mask, right? But this should be provided to them by you if you are going to require it, and you should train employees on how to properly use it. You could do things such as asking employees to do the self-assessment, the COVID self-assessment test that's been made available through the province on a daily basis. And, you know, depending on your situation, you could even require temperature checks in order to work. But if somebody refuses that, you can't, like, then they just don't come in that day, right? Because there could be many other things that can cause a fever that are not just COVID-19. You should also implement some, implement your policies with regards to self-reporting. So if an employee has COVID, ask them to self-report. If the employee has been in close contact with a confirmed case of COVID, you could ask them to self-report. So that is, that's it on this topic. I'll open it up to questions.
Kelly, there's a question related to what you were just talking about in terms of an employee that is living in a condominium that has a couple of people that tested positive for COVID. Mm-hmm. You're now saying that that employee should self-isolate, but I'm wondering what the rights of the employer are to force them.
Well, I think it depends on what the public health authorities are saying to this particular employee. So if the employee is living in the same, physical condo as somebody, that's one thing. But if it's just somebody who's in the different building and the public health authorities haven't said that they have to self-isolate, then I think they could still come into work. But if the public health authority is telling them that they need to self-isolate, then you can ask them to follow the advice of the public health authority and ask them to stay home until they've completed their self-isolation process.
I wonder too, though, that a lot of times there may, the health department may be busy, or there may be sort of unclear direction. So, if this employee in the condominium does have some kind of close proximity, even not living in the same unit, but maybe living down the hall, what are the rights of the employer? Because there could still be close contact even though they're not physically together. And again, there could be kind of unclear direction from the health agency.
Geez, that's a tough one. I think, you could ask the employee if they have been in close contact with that individual. I mean, just because they're living on the same floor doesn't mean that they've been in close contact. And it depends on, what the how the condo is sanitizing their elevators and all that, right? But I would, I think, if the employee is unable to get some information from the public health authorities, I would probably be safer rather than sorry, right? And just say, look, if you can, just work from home for the next couple weeks and monitor yourself for symptoms and try to get a hold of the public health authorities.
And I guess the challenge is if the employee refuses, then you just have to do whatever you can.
Yeah, I mean, you have to protect the health and safety of your staff. If the employee is saying to you, I have not been in close contact with this person, and I have not been told that I need to self-isolate, then, like, employers are not doctors either, or their employers are not public health authorities. And if the public health, and I mean, this is a changing situation, but I don't think that the public health authorities are saying that if there's a single person in a condo building that has COVID, that the entire building needs to self-isolate. I don't think that's what they have been saying. If the employee isn't comfortable with self-isolating and absent any information from the public health authority, and if the employee says that they have not been in close contact with that person, then I think you could allow them into the office, but just make sure that they stay away from other people as much as possible, right? Like maybe give them alternative duties for, like, a couple weeks.
Okay, thank you. We have a more general question
Mhm.
about whether a company is able to make a contract employee full-time and then apply for the wage subsidy.
So if you have somebody sort of on a fixed contract or an independent contract, I guess is what they're saying. Yeah, I think, the purpose of the wage subsidy is to get people back at work and off the CERB benefit, right? And so if you want to make somebody an employee, and they may already be an employee, but they're just being called an independent contractor, right? I think, yeah, for sure, you can put them on turn them into an official employee and give them a contract and then apply for the wage subsidy.
Okay, thank you. We have a question about resources that are available to companies, and just wondering if you know about any kind of a third-party vendor that can design online assessment tools for COVID-19 that can be used by employees and clients when they're coming into the office.
Online assessment tools for determining if somebody has COVID. Well, I don't know anybody who does that offhand, but you could use the self-assessment tool that's made available through the province on their website. But I'm sure there's many other companies who would be willing to do that. I just don't know of any offhand.
Yeah, and I guess I'm interpreting the question, but I think maybe it's related to people coming into an office building and making sure that you have some kind of proof that you've questioned them about their health, so that if anything happens down the road, you can say that you've mitigated it or you've taken every step to try and assess the situation ahead of time.
Well, as it relates to your employees, you can put that in your policy and tell them that they have to go through that self-assessment test. And, you can get them to confirm when they come in that they have actually done that. And then you have that record of them doing so. And as it relates to your customers, I think it would depend on your type of industry. Like I don't know if you can force a customer to go through that self-assessment, but you can put like a question, like you can put signage up and say, don't enter this premises if blah, 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 right? And if you're showing these symptoms.
Can you have them sign some kind of a waiver as they come into the office? If it's, somebody, a supplier or a customer coming into your office, and you get them to sign a waiver, is that a legal defense now that at least you've questioned them and they've verified that at the time they did not have COVID?
Yeah, I mean, there's certainly there's a certain assumption of risk on both sides here, right? So for your employees, they're coming in and they are, you've told them everything that you're doing, but they are assuming the risk that, especially if they breach the policies, they assume that risk. And same with your employees as well. Every time you go into a grocery store, you're kind of assuming a little bit of a risk there, because sometimes social distancing isn't really that possible. And it's the same thing for other businesses as well. Can you get them to sign a waiver? Yeah, you can get them to sign a waiver. I just don't know how enforceable that would be, but it can certainly act as a deterrent for people taking steps against you. The other question, the other point too, is that sometimes it's difficult, if not impossible, to know exactly where you got the COVID from, right? So causation would be an issue, I think.
Okay, thank you. We have one other question. And it relates to somebody riding in a car. So I think that may be as people are carpooling to work, mm-hmm. or it may also be, if you've got employees that need to be on the road together, mm-hmm. If one of the employees refuses to wear a mask while they're in the car, mm-hmm. can you send them home? Is there any recourse that employers have?
Well, yeah, I mean, if you put in policies in place to make sure that your employees are safe, and if one of your policies that you have is you need to wear a mask when it's not possible to physically distance yourself, and an employee refuses to do so, then yeah, you can send them home, because they're not following the policy. I would send them home. Like I would not like stop paying them. I would just send them home for the day, but then, you know, you give them a strict warning that if they do that again, there will be disciplinary action up to and including termination for cause.
Okay, thank you. Kelly, if you want, we can carry on with your presentation and then we'll come back to questions.
Sure. So now you've reopened and you're starting to recall your employees back to work. So some people might not want to come back, and they say, no, I'm not coming back. And don't assume that the reason they don't want to come back to work is that they're trying to shirk their responsibilities. So the first thing that you should do is determine the basis for their work refusal. In cases where an employee is sick with COVID, an employee is caring for somebody who's sick with COVID, or an employee is caring for a child who is not in school or daycare because they're closed, or that they're unable to return to the country due to COVID travel restrictions. In those cases, the government has actually amended the Employment Standards Act to give these individuals a protected unpaid leave of absence. And in those limited circumstances, you cannot ask for a doctor's note to prove their entitlement to that leave of absence, but you can ask for reasonable evidence that they are entitled to the leave. For employees who are sick for other reasons, right, and they can't do the job because they're ill, you can proceed in the same ways you normally would. So you can ask for a doctor's note. If the employee has a disability that prevents them from performing their job duties, what their restrictions are, and then you can determine if you can accommodate them in the workplace, for example, by allowing them to work from home. If an employee feels unsafe coming to work because of fears of COVID, I put these employees in two buckets, okay? So first bucket is employees who have underlying health conditions or an advanced age that makes them more susceptible to severe consequences of COVID. So for example, employees who have cancer, employees who have emphysema, people who have bad asthma, those kinds of things, and they feel uncomfortable coming into work because they might die, right? You may have a duty under the Human Rights Code to accommodate these individuals who have disabilities, right, with an unpaid leave of absence. If these people are insisting on working, but you don't feel comfortable with it, you can offer them an unpaid or, you know, in some circumstances, a paid leave, or allow them to return to work. However, if they are going to come to work, you can get them to, you know, sign a waiver and accept the risks of catching COVID at work in writing, right? And then at least, you know, there's evidence that you tried to get them to stay home, including on a paid leave. For others who are just generally uncomfortable with, you know, no real reason, right? It's just, well, I'm scared of COVID. You can, in conjunction with your joint health and safety committee, if you have one, meet with the employee to discuss their specific concerns. After meeting with that employee, you know, if there's things that you can do to satisfy their concerns or to make something more safe, you know, then you can let them know what you've done. If they still feel unsafe, they or you can contact the Ministry of Labor. They will send an inspector in to assess the situation, and they will determine if the workplace is safe or not. If the Ministry of Labor determines that the workplace is safe and the employee still refuses to work, you can argue that they abandoned their position, in other words, that they quit, and then they would not be entitled to a severance package and would not be eligible for either CERB or EI. But if the ministry determines that it's unsafe, they would probably give you some orders or different things that you need to do to increase the safety of your work's place. And if it's just really bad and if it's not possible, they may say, well, you got to close down because this is just not safe. From a practical perspective, when you return your employees to work, I would assure them that you've taken all reasonable steps to ensure their safety, and actually tell them what you've done. Tell them what the new procedures are and what policies are going to be in place to reduce the spread of COVID. I would add that if you have a work refusal for fear of coronavirus, you might want to contact an employment lawyer for advice about how to handle that specific situation, because it can get a little tricky. But another disability that can affect an employee wanting to come into the workplace is anxiety. Or some kind of a panic disorder. And if somebody has that, again, you would just treat it in the same way as you would with any other disability. Go and get a doctor's note. If the doctor's note doesn't give you sufficient information, you can push back. You can get more detailed information from the doctor to see if there's a way that you can accommodate this individual. If you're still not getting good enough information, like you always can, you can send them for an independent medical examination. And that's with whether it's anxiety or any other disability. So does anybody have any questions about work refusals?
We don't have any so far, so I think we're safe to.
All right, so let's move on. Employees showing symptoms. So if you have an employee who shows signs of COVID-19, you should immediately send them home. Now that testing is more widespread and less stringent, and I mean, this is a changing dial, right? Because they say they're going to be doing all this testing, then they're not testing as much, and now they're, like last week, they were saying that, they're going to start doing more and more testing in the community. Once that increased testing in the community starts happening, you can actually go and ask your employee to get a COVID test. If they test positive, you can require a negative test. I think they need actually 2 negative tests within 24 hours before allowing them to come back into the workplace. If they test positive, you could allow, if they test negative, you could allow them to return to the workplace. If they are refused a test, you can ask them to follow the advice that they got from public health, which, often if you're showing symptoms and you're refused a test, they still say, go home and self-isolate for 2 weeks and self-monitor your symptoms. Another thing you should do is take a hard look at your existing sick leave policy, okay? You don't want to give an employee a disincentive for calling in sick if they truly have symptoms, right? Like a cough or, a fever. So that means in order to give them incentive to stay home if they have these symptoms, you might want to give employees some more paid sick days than you did before. And you can make this a temporary thing. You can say, just for this year, we're giving you these extra sick days. If the employee is able to do so, you could still require that they work from home, provided that the extent of their illness doesn't prevent them from doing so, right? Because a lot of these cases are just going to be, the same as a regular cold. And, an employee has those symptoms, so you probably don't want them in your workplace right now. But they're still able to work. So if their job permits, you could still require that they work from home. So make sure that you have a clear policy that states how many sick days employees get. What does sick mean? So include that, if you're showing any of these symptoms of COVID, outline the steps that they must take to notify you that they're taking a sick day and what evidence, if any, that you require. But this is a double-edged sword, because if you have all of a sudden all these additional paid sick days, you're going to get employees calling in sick when they're not really sick. And you might get people who are malingering. So if you have employees that you think are abusing the system and don't actually have COVID, you could ask for a doctor's note to substantiate their entitlement to sick days. So right now, again, under the Employment Standards Act, if they have COVID, you can't ask for a doctor's note, but you can ask for information that's reasonable in the circumstances. But here they don't have COVID, they're just calling in sick. So you can still ask for a doctor's note to confirm, do they have a disability that would negatively affect the health and safety of their colleagues, or if they have a disability that prevents them from performing the essential duties of their job, what are their restrictions and what are their suggested accommodations. You can then assess the information and determine if you need to get them seen by an independent medical examiner. Right, so and this, we all know who these people are. They call in sick quite a bit. You might see that happening more so, and I would start looking at patterns, right? Like, are they all of a sudden really sick on a Friday? Every Friday they're sick, or every Monday they're sick. That could be a trigger. If somebody's calling in sick every Monday, it could also be a sign of substance abuse. So keep that in mind as well. But stay on them, and they might not want to go through the hassle of calling in sick when they're not really sick if they have to go through that process. But I wouldn't say do that with everybody. I would just say do that, start doing that with people where you see a pattern, or people who are, having a lot of sick days, a lot more than the average person. Questions about that?
We have one question. I'm not sure I'm going to interpret it correctly. So for the person that answered the question, if I don't get this right, just rewrite the question. But it's looking at post-COVID. Mm-hmm. So once we're back to normal, mm-hmm. With existing employee contracts, or even with new employee contracts, I guess if we focus on existing employee contracts, can they be rewritten and the wording changed to include COVID language now without penalty of changing the contract or the employee saying that something's been amended against?
Well, that is one of our big "it depends" questions. It depends what you're doing. Because if you are taking away significant rights from them, then maybe. But if you're just amending the policy, to give them extra sick days, or if amending the contract to give them extra sick days, then no, I don't think that would be like a constructive dismissal there. But a lot of the stuff in terms of sick days and a lot of the COVID stuff would really be policy issues, which you can change your policies and just make sure that you train employees on them. So I guess without knowing more information about what specifically the person who had the question was asking, it's hard to really say. So that's a very typical lawyer answer. It depends, but it really does.
Okay, that's it for the question, so we can carry on.
All right. Telecommuting. Okay, I understand that you've already had a presentation about this issue, so I will be brief here. You should have a clear policy about working from home and what your expectations are, including about safeguarding confidential information and network security. To ensure your employees stay engaged, you should regularly check in with them and establish metrics to determine their productivity. So any decisions to terminate later on, if necessary, are not arbitrary. If employees are entitled to if employees are entitled to overtime, you should absolutely get them to track their hours of work and ask for pre-approval prior to working overtime, because otherwise you might end up with a surprise claim for a whole lot of unpaid overtime, right? Because you're not there to know for sure how much they're working. If you do start getting these big claims for unpaid overtime, you still need to pay them for the hours that they worked, even if it was not, pre-approved. But what you do is you discipline for not following the policy, and then if they do it again, you can terminate or performance manage them in the same way as you normally would. You should also make sure that you have insurance in place to cover telecommuters. Most insurance policies do, but if not, you can require that the employee provides proof that they have insurance prior to allowing for telecommuting. And then in terms of workplace safety, this is a bit of an issue here. So although the Occupational Health and Safety Act on its face says that it does not apply to individuals who work from home while they're in their home, there is a bit of inconsistent case law in this regard. So there's a case that says that, the Occupational Health and Safety Act doesn't apply to this circumstance, but the WSIA, right, so somebody could get WSIB benefits, does apply. So, and then there's another case that said that it was a case where the individual worked from home, but they also drove and visited customer sites, and so there was a portion of their job that was not in their actual home, and it was found that the Occupational Health and Safety Act did apply in that circumstance, presumably because they said that the injury was caused, at least in part, from work that he did outside of the house. So I would err on the side of caution here. You want to ensure the workplace safety as much as possible. Certainly, you should advise your employees that your workplace harassment policies extend to cyberbullying, because people are very stressed and they act, I've seen some very strange things happen in the last couple months. So, make sure that you have that covered. Ask them maybe to take a picture of their workstation to ensure that there's no hazards, and provide them with tools if necessary to create a safe environment. But again, it's their house. You don't really control the environment, but you just want to show that you are taking, your due diligence. You're doing whatever you can in your power. And then I just have one more topic here, and it's terminations during a pandemic. So the law on terminations during a pandemic is, generally speaking, no different than terminations during the normal course. So I'm just going to do a Dismissal 101 for you. The first step is to determine what jurisdiction you're in. Most employers are provincially regulated, but there are some that are federally regulated, such as banks, right? Then once you know what jurisdiction you're in, you have to determine what the employee's statutory minimums are. So this depends on whether you're provincially regulated, in which case the Employment Standards Act would apply, and if you're federally regulated, the Canada Labour Code would apply. In a nutshell, the Employment Standards Act states that employees are entitled to notice of termination based off of their years of service, anywhere from 1 to a maximum of 8 weeks. You have to continue making contributions to their benefits during this time, and they accrue vacation pay during this time. You can force them to work through this notice period. Some employees, so those with 5 or more years of service who work at companies that have a payroll of 2.5 million or more, or who have terminated 50 or more people in the 6 months preceding termination, get statutory severance pay, which is an additional week or partial week of pay for each year or partial year of service, up to a maximum of 26 weeks. This piece, the statutory severance piece, cannot be provided in the form of working notice. Under the Canada Labour Code, you cannot terminate non-management employees without just cause. unless there's a shortage of work or a discontinuance of a business function. In such cases, employees are entitled to 2 weeks notice of termination or pay in lieu. And if they have more than 1 year of service, they get 2 days per completed year of service with a maximum of 5 days notice. So that's the statutory element. Under common law, unless there is an employment contract with an enforceable termination clause, employees who are dismissed without cause are entitled to what's called reasonable notice of termination. Reasonable notice is designed to give a reasonable person in the employee's shoes sufficient time to find comparable alternative work. There's no set formula to determine how much notice is reasonable in any given case, and any factor that can increase or decrease the amount of time it will take employees to find another job will be taken into consideration. The big factors are age, years of service, and position. Often, industry is also taken into account, and other factors such as an unsubstantiated allegation of cause can be relevant as well. So, we don't know yet how coronavirus will impact on notice periods. This is a big question mark. Under normal circumstances, a bad economy would increase the notice period because it will take employees more time to find another job than it normally would. But there is some debate within the employment community that courts might implicitly take pity on employers, because we're all in difficult situations, and reduce notice periods somewhat. Because if they don't, like, so many employers might go out of business just because they have to fire people, because it can get expensive. Reasonable notice is generally between the range of 3 to 24 months. Yes, months, depending on the circumstances. And this is inclusive and not in addition to the statutory notice period. Employees can work through the reasonable notice period. So you can contract out of reasonable notice. In other words, you can agree to some other amount of notice, but you cannot contract out of or provide less than their minimum statutory entitlements. Termination clauses in employment contracts are read very, very closely by judges. And if there's any reasonable interpretation that the clause violates the Employment Standards Act or the Canada Labour Code, it will be void and unenforceable, and the employee will have a right to reasonable notice. So my advice to my employer clients is there's always a range. There's a range of reasonable. I suggest that people offer something on the low end of reasonable, right? So it's not so low that just insults people and upsets them, and they just go running to a lawyer and sue you right away. But it's not something at the top end of the notice period that's extra expensive. Give them a low ball offer on the low end of reasonable. 75% of people will just accept it. The other 25% will ask for more, most often without a lawyer, and you can just give them a little bit more and they walk away. Then you have a few where a lawyer gets involved, and you still have some bargaining room to play with. Okay, so generally only about 1 to 2% of these go to litigation. You can offer your packages by way of a lump sum, in which case you can give a reduction in the amount within the notice period, or you can do a salary continuance with a provision that if the employee finds another job before the end of the notice period, they have to let you know, and they get a lump sum payment of 50% of the remainder. You can, in some circumstances, ask the employee to work through the notice period, or at least part of it, but that can get complicated, especially if the employee is a bad influence on the culture of the workplace, or if you think that they're going to start stealing clients or confidential information. So what I've seen through this coronavirus pandemic, are the following patterns. So first of all, employers are giving very, very low ball offers that would normally never be accepted. But employees are, by and large, accepting them, often with little adjustments, okay, unless they're mad. If they're mad, then all reason goes out the table, and people want to get even. But by and large, unless they're mad, what employees really want is something that they think is fair, okay? In determining what is fair, from what I've seen so far, and again, I do this on both sides. So I speak to employees, I deal with employers who are on I deal with both sides. But what I've seen is that by and large, employees tend to be understanding of the situation that we're all in, and are, also aware that if they go and fight and sue and get really aggressive, we don't know if there's going to be a company around in 2 years when the litigation goes through its course, right? So, they tend to be reasonable, and they're accepting less than what they normally would. But not all, right? Like, some will still fight. The most important thing that I've seen that's important to employees right now is, number one, an amount that's fair, but benefits is huge, because, God forbid they need them, right? And they're in the hospital with coronavirus. And the other thing is career counseling. Career counseling is something that helps employees put together their resume, helps them with job search, helps them with interview skills. And this is really important, especially if the entire industry is in a shakeup and somebody spent their whole life within a certain industry. And I would say consider holding career counseling in your back pocket, because it's something that often results in a deal. Okay, so, and always make sure to get a release. Prior to doing any terminations, especially mass terminations, you should contact an employment lawyer for assistance to determine what package should be offered, and to make sure that the termination is done correctly. So there is the end of my presentation. I'll just open it up for questions if anybody has any.
That's great. Thank you, Kelly. So again, if people do have questions, just simply put them in the Q&A box at the bottom of the screen. Kelly, this is kind of a crazy question, but right now, a lot of the emphasis is on the employee's rights if a company chooses to open.
Mm-hmm.
I'm wondering about companies that are nervous themselves about opening, but they're getting pressured by the employees to open. What rights do the employers have to say, you know what, we're just not ready yet. We want to stay closed. We want you to continue working from home.
I think the employer has every right to do that, because the employer's obligation to protect its employees, to protect its customers, trumps the rights of any one individual employee, right? It's even occupational health and safety is like, if you're accommodating somebody under the Human Rights Code, up to undue hardship, protecting health and safety constitutes undue hardship, right? So I think you have to be honest with your employees. Like, don't just not open because you're nervous. Like, you should take the steps that are reasonable to try and prepare your workplace. If you're not doing any of that, then an employee might take the position that it really is a constructive dismissal, because there's no hope of you opening anytime soon, right? But yeah, certainly if you're not ready and if you're still preparing, then don't open.
So we had one comment, which is complimentary. So basically saying that that the information was very useful, but this person is also saying that it seems like the notion is to have very clear policies, amend those policies if they need to be changed under the COVID environment, and then communication becomes the next key point to make sure that people understand that these are the new operating procedures.
Absolutely. And training on those policies, and particularly the social distancing and the health and safety policies.
You talked a little bit about the staggered workday, and maybe having some employees in one day, another group of employees in the next day, or doing a morning shift and an afternoon shift in the office. What obligation is there for then kind of cleaning the office and making sure that it's ready for the next shift of employees?
So again, I'm not a public health authority, right? So I'm gonna defer to the guidelines that have been put out by the Ministry of Labor for your particular industry, and and the public health authorities, but certainly I would think that if you are having two different employees sharing the same surface day after day, you would want to have those to ensure that those surfaces are clean and sanitized between each use.
And I'm not sure if any of the people who are online would do this, but you talked earlier about job sharing. So, you know, trying to prove to the employees that you're trying to create work, and maybe having two people sharing the same job somehow within one company.
Mm-hmm.
Is there an opportunity to share employees between companies? And what would the legalities be with that? So if a company has a truck driver, but they can't use that truck driver all day,
Mm-hmm.
but the neighboring company could use them, can they share that same employee?
I mean, yes. I'm just trying to remember the term of that offhand, but you would need the employee's consent for it. But then you would have an agreement between companies who's paying for what percentage of the salary, right? Would a situation like that qualify for the work sharing program under Service Canada? It might not. It might not. It depends on what the reduction is, because certainly they don't want any fraudulent applications. But you know, generally speaking, if you have two companies who want to share the wage of somebody, you know, you could do that if the employee agrees.
Okay, that covers all the questions. So obviously, it's been a very comprehensive and informative presentation. So Kelly, we want to really thank you for taking your time and offering that insight and expertise to our members, and for everyone that tuned in today. We thank you for your questions and for your taking the time to participate as well. So with that, our thanks to Kelly Gray from O'Connor MacLeod Hanna for your time and for again sharing your knowledge. And with that, we will call this COVID conversation to a close. Thank you for attending.
Thank you. Bye-bye.